almost right. Okay. The appeals process changes. Again, thanks to all of you on the call. We met with you, we met with self-advocates, we met with families, advocacy organizations, regional centers, and people shared a lot with us. And that was really important into finding ways to make this process better and more comfortable for people. So today, we are going to go over the changes, and then we're going to gather input for some informational packets and hearing officer training. Those are two of the big things that we're working on and that we have to have done by March 1st. So we are hoping that all of you will have good advice for us. The other thing that we did in the statute, and this really came about from feedback from the public about how important this work is at DDS, there's a new division of community assistance and resolutions. And what we've done is we've moved in risk assessment, quality assurance, the liaison to the Department of Healthcare Services, the self-determination program ombudsperson, the new office of the ombudsperson, and the what we're calling the Department of Community Appeals and Resolutions, which used to be known as Appeals and Complaints Project Section. So the idea is really focusing on all of the different ways that the community needs resolution and they need assistance, and how do we make the experience better for our regional center clients and their families. And so if you think about how that happens, that's through risk management, quality assurance, that's through the ombudsperson offices, that's through having a strong department that handles appeals and complaints. And so I think that this focus will be much better suited to really address the needs of our families. The new office of the ombudsperson, we're sort of calling it the Lanterman ombudsperson for short. One of their charges will also be to make sure that people have information and they understand their appeal rights, both because those rights are changing and also because it's complex and people need help understanding those. The ombudsperson is not a legal arm. We're not providing legal advice. We're not representing people in meetings. It's really that focus on the process and how people participate in that process. The office is also going to be doing training for consumers, for families, and for hearing officers. So lots of good work in this new division that I'm really excited about. And Pete Chervinka, who I think many of you know, this division will be under his leadership at DBS. So when we talk about the appeals process, and you notice people used to call it the fair hearing process, and we're now really focused on the appeals process because this process doesn't start at a fair hearing. The process starts much earlier. It starts between communication between a family and a service coordinator. It starts at the IPP meeting. It starts at how families are able to get and receive information from their regional center and how they're able to resolve disputes at that low level. And so thinking about how do we improve this whole process, not just make changes to the actual fair hearing, which you'll see we've done, but really to this process, to make this process better. So the first thing, and you'll notice on the slides that the statute that it's in is at the bottom and the effective date is in it. And the reason for that is different sections are effective at different points in time. All of them will be in effect by March 1st of 2023, but Some of them were effective immediately, July 1st of this year, and some were effective October 1st of this year. So, so the effective date is there. So one of the things that people talked about a lot was worrying that the regional center committee that the center uses to make decisions about eligibility and services didn't have the information that they wished they would have, that the committee would have had. Those committees are things like purchase of service committees, eligibility committees, living options. They all have different names at different centers. But we thought it was important to be sure that families had an opportunity to give those committees information. And so there was a change in the statute that requires those committees to have information about the client's need for the services, barriers that they have to getting services, and any other information that a family thinks is important for that committee to know. And so, and then the service coordinator would have to bring that forward. I think for some families, they'll probably, write that up. Other families will tell the service coordinator while she takes notes. So I think it might look different from family to family, how it happens, but it's really that opportunity for a family to share information. The other thing is that, for many families, the ability to attend meetings electronically was really helpful, because going in person to meetings was often very difficult, just in terms of transportation and timing. It was also hard for a lot of families to have people there to support them. It's one thing to get transportation to a meeting for yourself and your child and your spouse. It's another to get those resources in place for a close family friend or a neighbor, and so continuing to use electronic technology for many families enabled them to have supporters present at the IPP that wouldn't have been available in person. And so that change in the statute that went into effect for COVID, because now it's been codified until June 30th. It was just extended a year. I've had a number of people say, well, how do we make it last past June? Because we really like it and we like having options. And, that will come up before the legislature again this spring. And the legislature will have to decide if extending it permanently or longer makes sense to them. So, okay, some of you know me and have heard me complain about mutual consent in the past. And for those of you, I'm sorry, you have to hear me complain about it again. So under the current law, the regional center only has to send a notice of action if there is not mutual consent with the family. And here's the problem with that. We were all raised to be very polite and nice people, particularly to people that we view as experts or people that are authority figures to us. So if I call my service coordinator and say, my life is chaos, I don't know what's wrong with my son, things are so bad right now, can you increase our respite? And she, a very nice young woman, says, oh, I'm sorry, no, you know what, we can only give 24 hours a month, that's all we're allowed. I'm so sorry, have you tried asking relatives to help? And you said, well, no, I did, and they can't, but, I appreciate, you talking to me, thanks. Was there consent in that conversation? I can tell you my service coordinator is going to say, yeah, mom said she was okay with it. So I didn't send a notice of action. But if mom calls Jalalia or runs into her at a training a week later, and Jalalia says, how are things going? She's going to say, things are awful. And I asked for more services, but they told me no. And Jalalia is going to say, well, did you get a notice so you can appeal that? She's going to say, no. And so there's this disconnect in experience that happens under the way the law is currently written. And so after March 1st, there will have to be affirmative agreement to the proposed change or denial. And what that affirmative agreement would be is you've signed the IPP that affirmatively says, mom asked for more respite and was told no, or mom was getting more respite, we're lowering it. Mom, mom said, okay, we can lower her respite. It has to be affirmatively listed. It could be that the family signs a list of agreed upon IPP services. Once again, though, that proposed change or denial has to be affirmatively listed. The other thing a family could do is sign another written document with the change, or denial affirmatively listed. So a family could send an email or, something like that. But it really has to be affirmatively indicated. The other thing that can happen is if a regional center truly believes that you are okay with that change or denial, then they're going to send a confirming letter within 5 business days. And that confirming letter will explain what the change or denial was. It will explain why they believed that you were in agreement with it. It will apprise them of their appeal rights and how, that a notice of action can be sent to them. And so I think this does a couple of things. I think it helps better advise people of their rights, but I also think it helps move the conversation about disagreement in a little different way. My 10-year plan for the system is that we get to a place where we can talk about disagreements very openly and very candidly, so that there's not all of this fear around it and, on both sides. That's going to require regional centers to change. That's going to require families to change. There's a lot to that, but that is my 10-year dream. So for today, though, we've got a change in the law around mutual consent. Okay, the other thing we're going to do, because what we heard from people was we don't like your forms. And that was pretty universal, that people did not like the notice of action form. They didn't like the request for hearing a form. People did not like our forms. The other thing we heard from people beyond forms was that, the information that they received from the regional center with their notice of action, it was sort of all over the place. Every regional center sends something different. Some of them are 50 or 60 pages long. And so if a family has to decide very quickly whether or not to appeal in order to get aid paid pending, they don't have time to read a 60-page packet. And so, what we've done is that DDS is going to create an informational standard appeals packet, one for Early Start, one for Lanterman. The packet will include the appeal form, the new and revised form, and it will be translated, of course. The regional centers have to give out that packet at IPP meetings. Remember, we're starting to talk about disagreements in a more, kind of comfortable way. It's okay to disagree. They'll send them out with all notices of action and anytime someone asks for one. The regional centers and DDS also will have that packet posted to their websites. And what I don't want to have happen is that we create a packet that no one ever reads. That would be a very bad outcome for so many reasons, including, that Catherine and I are going to put a lot of time into it. So we want it to be something really good and useful. And that's where we've come to all of you. So be thinking, what would a good packet look like? So those forms, like I said, we've heard you all loud and clear. Yeah, bad forms. So the forms are going to be plain, clear, and in non-technical language. They, of course, will be translated. The notice of action will, of course, include all of the information. We're also working on online forms for people, but of course, we'll maintain paper forms so that people who don't have access or aren't comfortable utilizing forms online can still use paper forms. And the other form that we're going to do work on is the appeals request form. And part of why this needs to be revised, in addition to people not liking it, is in this, in this appeals process, we really want people to be able to choose their different steps at different points in time. So I think a lot of people were hesitant to send in an appeals request form previously because it was a hearing form and they were asking for a hearing. And I think a lot of families are like, I disagree with the regional center's decision, but I don't know if I'm ready to do a hearing. That sounds scary. And so this form, you can pick. You could pick one of the parts, you could pick all three of the parts, and you can change your mind as you go. So maybe you don't know if you really could do a hearing or you want to do a hearing, but what you do know is that you want to participate in a mediation. And so you can choose mediation. And then if that doesn't work, then maybe you decide, you know what, I can do a hearing. You could then come back and say, and now I'm in essence checking the hearing box. And that gives people the ability to feel less pressure in that very first moment and to make some decisions as time goes on and as they're participating in the process and maybe learning. So the form, of course, will tell them how to submit the form and, contact information, etc. One of the things that's important about telling people where to send the form is under current law, when you fill out a hearing request form, you send it to your local regional center, which a number of people told us felt awkward at best because the same people who denied you something or are cutting something are the people that you now have to ask for a hearing. And so that just didn't set right with people, which I get. And so instead of filing with the local regional center, all of the appeals are going to be filed with DDS after March 1st. And then DDS would send, the relevant information to the regional center if people request mediation or hearing, also to OAH, but it's really going to start at DDS. The other thing that does is, frankly, it gives DDS a lot more insight into, how those hearings are being requested, and they're better able to track information about the hearing, request process and how that's going for people, which I think will be really instructive to us in the future, being able to have better data. Okay, those were really just the basics, right? And I think good stuff already. But I'm going to turn it over to Catherine, who's going to go over some specific changes, and you will see lots of even better stuff that I think is going to help our families. Catherine?
Thanks for that, Katie. And I think we can go to the next slide. I'm going to talk about some specific changes in the statute and the appeals process. The first one reflects many of the comments that you made to the department and others, is that sometimes interpretation is not very good. And so the statute now has a standard that has to be followed by whether it's the regional center providing an interpreter at an informal meeting or the Office of Administrative Hearings for either a mediation or for the hearing. And it says that the person must be able to interpret effectively, accurately, and impartially, and the person can both understand and speak both languages. So sort of the basic standards of what we would all expect of an interpreter. I think this is important information to get out to families, because if the interpreter doesn't meet this standard, it is something that people should raise and say, this interpreter isn't working, we need to find someone else, here's why. This particular part of the statute, as you can see, is effective immediately upon passage of the statute, which was July 1st. So this standard is in effect right now. The second on the next slide, thank you, Katie, is the timelines for appeal. One of the most common pieces of feedback we received, as Katie mentioned before, is that the timelines often felt too short. So the timelines have been extended to allow people to better think about what steps do they want to take. Sometimes people want to have another conversation with someone at the regional center informally before they initiate an appeal, or maybe they just want to speak to their family or other people they trust about what options make sense. So this is designed to allow those things to happen and to let people have just a little room to make the decision that's going to be best for their family. So the current appeal process requires that you file an appeal within 30 days. That timeline has been extended to 60 days, so doubled. And if a family wants to receive the services they currently receive during the pending appeal process, that's called aid paid pending. Currently, that was a 10-day, very short window of time to file the appeal, and that's now been extended to 30 days, although it also has to be before the date that the regional center was going to change the services. So if there's a mailing of a notice, it could technically be a bit less than 30 days. And that's effective on March 1st. The next slide shows you what the timelines are for each step of the hearing process. I think one of the most significant things that changed is now everything is a calendar day. We all know what calendar days are. You count the days on the calendar and you say what is 10 days from now, right? Or what is 90 days from now? The current statute used a variety of days. It sometimes said business days, it sometimes said working days. Each regional center had a different set of working days based on whatever schedules they had when they were open. So we felt like it was just clearer for everyone if we said it's going to be calendar days. It's also important to remember that families can request a continuance of the timelines that are here, and you'll see later the continuance can be initially requested for any reason for the first request for a continuance, and after that there has to be a good cause. So this again is effective. This change to calendar days is effective on March 1st. I think one of the most important changes in the statute is the change to the mediation requirement. Currently, if a family requests mediation, the regional center has the ability to opt in or opt out of mediation. This instead, the new statute effective March 1st, is that if a family says they want to mediate, then there has to be a mediation. And mediations are conducted by mediators that work for the Office of Administrative Hearings. So I'm hopeful that families will avail themselves of an opportunity they didn't often have before. It's often a very good way to resolve a dispute. It's the most common ways disputes are resolved in the special education system. And so one would hope that that would also happen in the regional center system, that there'd be a new way to reach an agreement with the help of a third party. There's two other kind of steps to the appeal process. After the final decision has been issued, the DDS director can review that decision. So in that case, if the director indicates they want to review it, the hearing officer will issue a proposed decision, and the director can then review that decision. We think that's most likely to happen on matters that involve sort of new policy issues. So right now we're implementing provisional eligibility. The director might say, I want to look at provisional eligibility cases to understand how those decisions are being made and make a decision about that. The second change is something that happens after the final decision, whether that's by the hearing officer or by the director, which is if a party believes that there's been a legal, factual, or clerical error, they can ask for a reconsideration within 15 days of the decision. And then the hearing office or the director will grant or deny the request for a reconsideration within 15 days. Sometimes those can go as far as having a new hearing, and that new hearing would be under the same timelines as the current hearing process. Other times there'll simply be a correction if it's particularly if it's a clerical error that just needs to make the decision accurate. The last change is that there's an appeal to court within 180 days. Currently, that was for 90 days. So this is designed to give families more opportunities to identify someone who could help them with a court appeal. One of the most significant changes is a change about when an attorney can attend any step of the appeals process. So a regional center cannot use a lawyer at an informal meeting, mediation, or hearing unless the family is a lawyer or one of the family members, or they have a lawyer with them. The family must tell the regional center if they're bringing a lawyer to the hearing 5 days before a mediation and 15 days before a hearing. So there's a notice requirement. This was effective on October 1st. And as you'll see in the slide, there's a directive that was sent out to the regional centers about the use of attorneys prior to that effective date. So this is an attempt to equalize kind of a playing field and help make hearings less formal and intimidating for families. We talked briefly about the continuances before. So the claimant's first request for continuance prior to a hearing shall be granted without a good cause showing. They can make more requests with a good cause showing. Good cause follows the typical reasons, such as there's an illness in a family, or there's a death in a family, something of that nature. Regional centers can also request a continuance for good cause, and that goes into effect on March 1st. There was a lot of discussion about the exchange of evidence requirements, and also about how do families better understand what position the regional center will be taking at the hearing. So there's two pieces to this. One is about a position statement. This is the something that regional centers will be required to do, which is provide the family with specific information about their position at the hearing, listing all the witnesses and providing copies of all the evidence that they want to use at the hearing. And it has to be provided to the family 2 business days before the hearing. It also has to be in the family or regional centers consumers' preferred language so that they can actually understand what the regional center's position is. If it's not translated by the regional center can ask for a continuance for 10 days to complete the translation. The family has a choice to decide they want to proceed without a continuance and without getting the document in their preferred language, or to otherwise they can agree to the continuance of the hearing to allow that to happen. Good, thank you. So if for families, there has been a reduction in what families have to provide before the hearing. They have to provide a list of witnesses and how they know the family or the regional center consumer. So a brief description: this person's my neighbor, this person's my physician, something short like that. They have to provide a copy of any professional assessments or reports that they want to use at the hearing. And then at or before the hearing, they provide all the other documents that they want to introduce. So before, there was a kind of a mutual exchange of a lot of different information and a lot more detail, which family members found difficult to provide, difficult to submit through the electronic portal that OAH was using. So this is to allow for much less information in terms of what families are required to provide prior to the hearing. Families don't have to provide a position statement unless they're represented by an attorney, and then they follow the same obligations that that the regional center would have. And all of that's effective March 1st. Another concern that we heard is that sometimes it's hard for families to get the hearing decision where they prevailed implemented. So this was effective on July 1st, that regional centers must carry out the final hearing decision within 30 days of that decision. If they can't do that, they have to notify the claimant, the family member, the regional center consumer, their authorized representative, and DDS, the exact reasons why what makes it impossible for them to implement it and when it will be implemented. And families have the option of now going to DDS and saying that they need help in getting the hearing decision implemented. And DDS is obligated to assist with that. The next section is changes to how the hearings are going to be conducted. One of the concerns is that hearings had become very formal and that families didn't feel comfortable participating in the hearing. And so hearing officers will now be required to use a different way of conducting hearings, which is called engage neutrality. And this is where the hearing officer has an obligation to make the hearing environment comfortable for sharing information. And the hearing officer has a responsibility to help important facts come out. The hearing officer can ask questions. The hearing officer can call someone to testify at a hearing, and they can give one party or the other time to get the needed information or documents before they write a decision. So this means that the hearing officer should play a more active role in the hearing, not just say present your case, but help understand what areas they might need information about so that they can render a decision. As Katie said at the beginning, there's going to be administrative law judge training. And training is going to include how to create a good hearing environment, how to help people without lawyers, people with disabilities, help hearing officers understand what the impact of a disability might be, how people might communicate in different kinds of ways, and help them understand the importance of listening to the different communication styles that people might have. There's going to be training materials developed, and part of our ask today is that you help us think about what those training materials should look like, and there'll be other opportunities for stakeholders to participate in that. The Office of Administrative Hearings is going to create an advisory group for regional center hearings. This will be similar to the advisory group that it exists currently for special education hearings. So the hearing office with DDS must form the advisory group with stakeholders in it. They're going to meet 2 times per year. They're going to give non-binding recommendations for improvements to the fair hearings and to mediation. There's an expectation that that group will include individuals who participated in hearings as a family member or as a self-advocate, with the idea that having a very diverse group of participants will help the hearing officers in the end do a better job and hear firsthand from family members and self-advocates about how the hearings are going and what steps the hearing office can take to make that a better process for the participants. So that leads us to the important part for us about the hearing process is about the appeals process is for you to provide us with some input. And thank you for all the comments in the chat that you've already given. I was reading those before I started presenting, and I thought some really good ideas there. But we want to know about, in the information packet, what are the most important parts to include? What is the best format for the information packet? Are there other helpful materials that you already know about? Do you have ideas about how to get these into the hands of people that need the information? And talk a little bit also to us about the important things for hearing officers to know. So I think Katie's going to